purpose that they, quote, outline the principal analytical techniques, practices, and the enforcement policy of the agency. And I think they have two basic purposes. The primary one is to educate the business and other communities that participate in the agency process about how the agencies think about mergers so that those participants can understand the process and participate most effectively in it. The secondary purposes, I think, are to first ensure that the agency lawyers and economists are all on the same page with respect to enforcement methodology and philosophy. And second, to educate courts and other constituencies about the agency's views as to the prudent way to think about merger policy and law.
Is there any particular reason, or at whatever point that they decided to issue separate guidelines for vertical and then horizontal mergers?
Well, I don't think there's a substantive reason. In fact, in my view, there should be one set of guidelines, in part because I think it's a mistake to think of mergers as being vertical or horizontal. I think it's better to think of merger theories or competitive risks being those potentially of a horizontal or nature, elimination of rivalry among substitutes versus more attenuated or complicated theories involving acquisitions and merger complements. No, I think the reasons are probably twofold. First, an historic accident. The original merger guidelines were horizontal merger guidelines published in 1968, and at that time, I don't think there was much concern in the antitrust community about the vertical mergers, and certainly they were not perceived as frequent a problem as horizontal mergers, and therefore didn't warrant the first ever effort at comprehensive guidelines. And I think the merger guidelines have just existed on a separate path and been revised from time to time since then. The second reason, and maybe the more important one ultimately, is that there's, I think, always been less agreement substantively about the appropriate approach to take toward vertical mergers than that about horizontal mergers. So it's been much easier to reach consensus within the agencies and between the agencies on horizontal mergers analysis than on vertical merger analysis. And certainly we've seen that most recently with the FTC withdrawing unilaterally from the vertical merger guidelines. So I think that failure of consensus in view has inhibited the development of vertical merger guidelines.
So, Bill, the request for information sort of shares, I think, to some extent, Doug's perspective on the need for two separate documents. What are your thoughts on that? It's kind of, what does that pretend for those who must worry about compliance and enforcement issues?
Yeah, actually, I hate to correct Doug as to the merger guidelines history, but in fact, the 1968 guidelines did have both horizontal and vertical guidelines in them. They may even have had a section on conglomerate mergers, although I'm not 100% certain of that. Likewise, the 1982 guidelines that Bill Baxter wrote also covered both horizontal and vertical mergers, as well as mergers involving potential new entrants. The same was true in 1984. It wasn't until Jim Rill was head of the Antitrust Division in 1992, excuse me, that the DOJ issued a separate set of horizontal merger guidelines. And I think those were the first guidelines that the two agencies issued jointly. So, there's a long history of having horizontal and merger guidelines in a single document. And I agree with Doug. I think that they belong in a single document because I don't think that very many mergers any longer are purely horizontal or purely vertical or purely conglomerate for that matter. A lot of mergers involve mergers between companies producing products that I would view as complements, which are neither vertical nor horizontal and would be classified by some people as a conglomerate merger. In addition, if you look back at the very first merger case, the Supreme Court decided under Section 7, after it was amended by the Seller-Kefauver Act in 1950, the Brown Shoe case. That case included a section on the vertical aspects of that merger because the two companies were both competing in the manufacture of shoes and in the retail distribution of shoes. And so it was a horizontal merger, both at the manufacturing level and at the retail level, plus it was a vertical merger. And I think that's true of most mergers, many mergers, if not most, that come before the agencies now.
And any thoughts on that? No thoughts? Okay.
I'm sorry, were you addressing Ken or?
Yes,
Well,
Ken. Sorry.
no, I mean, I agree with that. I mean, a lot of it is history, and more important is kind of the substance and the implications of all of this. And so, you know, we can talk a little bit more about that. I certainly defer to Doug and Bill on what they've just said.
So Ken, looking at the RFI as a whole, kind of what jumps out at you as an economist and someone who spent his career at DOJ and FTC dealing with the complexities of antitrust economics?
Well, one thing that I found interesting, I mean, it's very long, as you mentioned. This request for information covers just about every topic you could imagine that has to do with antitrust and more. Much of the request for information strikes me as getting into ground that has actually already been covered and covered quite well by the current merger guidelines. So I'm thinking, for example, about the analyses of unilateral effects, even coordinated effects, vertical merger guidelines that have since been withdrawn, but did a reasonable job of framing the landscape for vertical work. So I think that with the important exception that the current leadership of the agencies clearly wants to be more aggressive and have different presumptions and different thresholds for attacking mergers, perhaps, and also different presumptions about efficiencies in the case of vertical mergers, certainly. I think that a lot is similar and won't change dramatically in terms of the core analytical framework. Now, there are some areas that clearly do seem to be different. One, I think, has to do with perhaps conglomerate mergers and emerging theories about how mergers that may not raise clear horizontal or vertical concerns traditionally could nevertheless present concerns. For example, there are growing theories about how combining products for a firm that sells or buys from somebody else by bundling them together and making an offer to sell both of them rather than the individual ones could give greater bargaining power to a firm. And so I think that's something that may be looked at. It's happened to an extent already in hospital mergers where sometimes firms are competing to be in insurance networks, and it raises those issues even if the firms themselves don't serve the same patients. The other area that I think it's perhaps important to think about has to do with efficiencies and what the RFI seems to be suggesting or signaling in that area. One thing about efficiencies that people sometimes maybe forget is that notwithstanding what some of the more progressive folks tend to say about overdoing the efficiencies presumption in mergers, the courts, as Doug and Bill know very well, have not been particularly receptive to efficiency defenses over the years. And although the agencies do consider them and have them in the current guidelines, they tend generally not to make the difference in a merger analysis. The one thing that I did want to flag and get reactions from, though, had to do with the very striking reference in the document to one particular Supreme Court decision, the Procter and Gamble case, which stood for the proposition that efficiency defenses not only can be dismissed as not being relevant or sufficient, but went even further than that and argued that efficiencies themselves can be a reason for blocking a merger. And I think that the thinking there, and here I'm worried a little bit about what it might mean for mergers involving platforms and other highly diversified companies. What I suspect the agencies might be thinking is that by making already successful, or one might say dominant firms, even better, by letting them take advantage of further scale and scope economies, that this can make it even harder for other firms to compete. It can raise barriers to entry higher than they are already, because now you have to compete with an even better firm than before. And that could make entry less likely, or growth by smaller players less likely. And this would be a significant jump from the way efficiencies have been viewed over the past quarter century or more, which was that on balance, if you lower the costs of a big firm or increase its attractiveness, that's a reason for permitting the merger, not a reason to be cautious about the merger. So that, I think, is something to pay attention to.
There's a lot to unpack there, but I'll I guess direct one specific question from all of that to Bill, which is, what would your answer be to the first question in the sort of efficiencies section of the RFI that reads, is the guidelines approach to efficiencies consistent with the prevailing legal framework as enacted by Congress and interpreted by the courts? Ken seems to suggest that there may be differences among courts on those kinds of issues, especially over the time period that we're dealing with here. You're on mute, Bill.
When it comes to the need to consider efficiencies in evaluating the likely competitive effects of a merger, I think that question actually reflects a fundamental misunderstanding about the purpose of the antitrust laws on the part of the people who drafted the question. As Ken Heyer said to me once when we were working together at the Antitrust Division, efficiency is the goal, competition is the process. Unless you think that's just a view that's unique to Ken and me, back when Doug was at the Antitrust Division and Joel Klein was the AAG in charge of the division, an OECD report. OECD has a competition committee that meets in Paris 3 times a year and is attended by the competition agencies from the 30 or so industrial countries that belong to OECD. And that report explained that the basic objective of competition policy is to protect competition as the most appropriate means of assuring the efficient allocation of resources and thus efficient market outcomes in free market economies. That is a central goal of antitrust, and it always has been. If you look back to the Senate debates on the Sherman Act in 1890, which I happen to have studied and written an article about, John Sherman on the floor of the Senate assured his fellow senators that his bill would only prohibit the, quote, unlawful combination, which would harm the public by lessening competition and raising prices, and not the, quote, lawful combination, which would promote trade, not restrain it. Chief Justice Edward Douglas White, in his opinion in Standard Oil in 1911, dismantling the most infamous trust of that era, the Standard Oil Trust, said exactly the same thing in formulating his rule of reason test for application of Section 1. And guess what? In 1914, Louis Brandeis's principal assistant in drafting the Federal Trade Commission Act and lobbying for its enactment by the Congress, a fellow by the name of George Rubley wrote a speech for one of the principal proponents of Section 5 of the Federal Trade Commission Act, which Senator Henry Hollis, that proponent, gave on the floor of the Senate. What he said is that fair competition is competition which is successful through superior efficiency. Competition is unfair when it resorts to methods which shut out competitors who, by reason of their efficiency, might otherwise be able to continue in business and prosper. And it didn't end there. In 1950, when Congress amended Section 7 of the Clayton Act, one of the changes they made was to change the language of Section 7 from prohibiting any merger that eliminated competition between the two merging firms, i.e. all horizontal mergers, and replace it with a test that only prohibited those mergers that would substantially lessen competition in any line of commerce in any section of the country. Why did they do that? They did it because there was a lot of concern in Congress. After all, Esty Kefauver was the chair of the Small Business Subcommittee of the Judiciary Committee. There was concern that the previous language of Section 7 would prohibit mergers of smaller firms that needed to become more efficient to compete with their larger competitors. I don't know who wrote that question, but they really don't understand the history of the antitrust laws.
Doug, thoughts?
Well, I agree with Bill's bottom line. I think look, let me back up a minute on the question. What jumped out at, you asked earlier of Ken, I guess, what jumped out at him from the request for information? And what jumped out at me, in addition to what was said, was how tendentious the questions are. It's a little bit like, I think, the House Committee report, frankly, in it was a point of view looking for ammunition rather than an inquiry of people who really want to learn what the right point of view ought to be. That's point one. And second, the exclusive implicit focus on the cost of false negatives. Let's make sure we don't ever let an anti-competitive merger get through. No concern at all about the risk of false positives. And I think what drives this is a conviction that antitrust ought to be, and probably a good faith belief that antitrust is, about preserving some kind of Jeffersonian image of the small entrepreneurs competing in Jeffersonian democracy and so on. But I think the mistake, and it goes back in a way to what Ken was saying about the difference between means and ends. The mistake is that would be analogous to saying that the patent laws ought to ask courts to decide what will promote invention. And it doesn't do that. The patent law selected a particular means, a particular instrument, the patent law with its requirements of novelty and so forth. And the courts are supposed to apply the instrument. Here, I think the Sherman Act and the Clayton Act were a particular instrument. They're focused on bad conduct, not on equality, not on fairness. And I think that Bill's much more learned review of the history is right. They're focused on a particular notion of competition, which has to do with economic welfare, not simply with multiplying the number of rivals and preventing any diminution of rivals by either acquisition, mergers among small firms, or losing out in the marketplace to more efficient.
So the commission and the antitrust division have indicated an interest in focusing more on labor markets and disruptions. So one of the areas where efficiencies may be seen as a negative would be if workforce reductions were used to reach efficiencies. Is that something, Doug, that you think is going to attract a merger challenge more than it may have in the past?
I think there's no question that the political appointees in this administration are very focused on labor markets in particular. Sometimes they talk more broadly about input markets, but they're really, I think, focused on labor markets. That's part of, I think, a broader focus on equality and fairness rather than economic efficiency and economic welfare. So if they could pass legislation that would enable them to achieve the kind of result that's implied by your question, I suspect they would want to do that. In the absence of that, I think that they're facing a fairly clear law that would say, look, a merger that creates monopsony power in labor markets and reduces output of labor, reduces headcount in labor by the predicted exercise of monopsony power, I think that clearly would be a cognizable violation of the antitrust laws. And I think the agencies will be looking for cases of that type. And probably the agencies have been neglectful in the past in not focusing on that question. But I think what your question is really asking is not what happens when a merger creates monopsony power, but rather what happens when the merger enables the merging parties to have an efficiency prompted workforce reduction. I think while the agencies might well want to challenge mergers like that, they probably, in the absence of legislation, will try to do more sophisticated cases that plausibly raise traditional market power concerns, rather than just saying, well, you can't reduce your workforce after.
I want to note that I just added a link to the chat function of a paper that Bill wrote for us last year that contains a lot of the historical information that he was talking about a few minutes ago. So I definitely recommend that to you. Bill, go ahead if you want to.
Yeah, I'd like to just agree with Doug and add a little bit more color to what he was saying. I find this suggestion that there should be more focus on the impact on the workforce and the possibility that a merger that reduces the number of workers needed to produce a certain level of output might be challenged for that reason alone. And that's turning everything I know about economics on its head. And it's ironic coming from an administration that right now should be, and I think is, worried about inflation and the effect that that's having on consumers, and also is worried about the competitiveness of the US economy and the desire to enable US companies, especially manufacturers, to compete more effectively with other countries in order to reduce the trade imbalance in this country and protect and create more jobs for American workers. Economists have always thought of getting more output out of the same number of workers, or getting the same output from a smaller number of workers as an increase in productivity. And that is one of the driving engines of a growing dynamic economy. So you have to be troubled by the suggestion that we're going to discount those types of efficiencies.
Thanks, Bill. Ken, go ahead.
Just to add my 2 cents, I agree with both of what Doug and Bill said. I think that the agencies are indeed going to look very long and hard to see if they can find any monopsony problems where labor is being reduced because of an exercise of market power by the merged company against them. And as Doug said, that fits right into traditional analysis. It's basically contained in the current guidelines, absent reference to labor per se. However, I think that when the agencies do bring cases, perhaps for other reasons, they will be quick to trumpet the fact that by maintaining competition, it will also maintain employment by which tends to go along with greater output. And so I think that from a public relations standpoint, if nothing else, they'll talk a lot more about labor. But as Doug said, I can't imagine courts ruling that a merger is anti-competitive because it creates a more productive firm that requires fewer workers per unit of output.
Let's talk a little bit about how the RFI looks at market definition, which is certainly a major issue in merger review and merger challenges. What do those questions sort of tell you? Can probability of harm to competition be determined without defining the market?
Well, I think you can demonstrate harm to competition without defining markets. And once again, I think this is an area where the current merger guidelines do an excellent job of providing the framework for determining when removing one competitive constraint on another firm can lead to higher prices, something that can be done without defining the contours of the market and calculating shares of everyone. So I don't think that really changes very much, especially in differentiated products mergers. Defining markets and calculating shares can, as extensive commentary has demonstrated, often cause more confusion than guidance, albeit while raising the costs of businesses who have to hire economists and lawyers to spend a great deal of time defining markets, which may not even be necessary. I think that the guideline, the current focus in the guidelines, though, is both to try to argue that mergers can sometimes be anti-competitive, even if markets haven't been clearly defined. But on the other hand, they also want to have a presumption of harm with lower concentration levels, which I think by itself requires that a market be defined in order to calculate shares and say something like a merger that increases the market share above 30% is troubling. So I believe that where they're going to end up is, again, sort of where the current guidelines are, which is sometimes direct evidence can be used and can be enlightening as to a merger's competitive effects. But at the same time, when they do define markets and when they do find it necessary to define markets in a particular case, they'll use a lower market share as a presumption of harm, drawing on what they would say is the legislative and judicial history of determining when one ought to be concerned, and also recent scholarship by a number of people that suggest that the agencies perhaps should have been challenging more mergers where market concentration was lower and have inappropriately raised the bar for challenging concentrating mergers.
Doug, Bill, any thoughts on the market definition questions?
Well, I'm going to say that generally, without repeating much of what Ken said, I think antitrust law in general suffers from being too complicated. I think if you look at court decisions where the courts have gotten, at least in my view, wrong, except for some Supreme Court cases that seem to be driven by ideology, the lower courts are getting it wrong, I believe, because they just don't have a clue. They don't understand it. These aren't economists, these are generalist judges, and they're faced with all of this these checklists of things. They define the market shares, categorize the conduct. What, is it loyalty discount, is it exclusive dealing? What is the applicable rule? And I think they get all tied up. And so I do think it would be healthy to simplify antitrust law, to use economic tools where they're useful, but not create a world in which everybody thinks, well, we have to do a diversion ratio, we have to quantify this, and you can't quantify, plaintiff loses. I think that's kind of a nutty way to think of antitrust. So I certainly would welcome a thoughtful and careful emphasis on the value of direct evidence and getting away from some of the requirements like defining markets, which, after all, are limited value when we're dealing with heterogeneous firms and heterogeneous buyers, because the simple market notions are at their most valuable when everything's homogeneous and you can really talk about cars compete with cars and railroads compete with railroads and they're the twain meet. That's not the real world. So I hope we move in that direction, but I worry that they will move that way without the kind of rigor and economic focus that would be required to make the decision.
Yeah, if I could follow up on that, Glenn, I could probably spend the entire day talking with Doug and Kenneth and you about market definition. But I think that the key thing that we all need to remember is something that Justice Stephen Breyer, who is just retiring from the Supreme Court, has said in a number of his opinions dating back to when he was a judge on the First Circuit. And that is that we have to remember that the antitrust laws are not intended to be just applied economics. They have to be administrable. And that is a very important principle. That's a very important thing for us to remember. And it's a lesson that Steve Breyer in turn learned from Don Turner and from Derek Bach, who was the dean at Harvard when he first started teaching there, which is that, as Doug said, judges and juries are not going to be able to understand all the complexities necessary to do a rigorous economic analysis of the likely competitive effects of the merger. And that's the reason why you need presumptions. And in order to have any set of structural presumptions, you need to define the relevant market. If you read, court decisions over the last 20, 30 years, almost every merger decision comes down to the definition of the market. They really do. And I think that's one way that you can make the antitrust laws more easily understandable, both to the lay public, to the business community, and to judges. I think the original merger guidelines that Bill Baxter issued in 1982, that was the second set of guidelines, but probably the first that was really well informed by economics, took a very somewhat oversimplified approach, sort of a 5-step analysis of how you analyze a merger, starting with defining the markets, starting to look at levels of concentration, market shares, et cetera. I think the more recent versions of the guidelines, beginning with the 1989 version, but especially with the 2010 version, got away from that very straightforward and concise analytical framework. And I think there is a lot to be said for going back toward that. The other concern I have on market definition is what has already been happening and really started happening way back in the early 1980s, of the agencies basically gerrymandering markets, defining them more and more narrowly until they can find a market where the concentration levels are high enough that you're going to be able to persuade a judge that they've made out a prima facie case, the merger is likely to substantially lessen competition. Shift the burden to the defendants to try to rebut that prima facie case. And as I think Ken said earlier, that's something that the defendants almost always fail in doing. One consequence of that, I think, is the increase in concentration that we've seen in our economy as a whole, because the agencies have focused too much on the short-term price effects in narrowly defined markets and lost sight of what's happening in the larger industry, not just in particular local or narrow product markets. And that's the one place where I would actually like to see some reforms made, where the agencies would look more broadly at potential cross-market effects in terms of economic concentration, as well as on prices and innovation in doing their merger analysis.
Yeah, Glenn, let me pick up a little bit on what I suspect may be a further question you had having to do with sophisticated quantitative analysis and how that plays into all of this. Bill has, I think, correctly stated the argument for using presumptions and by implication getting away from very sophisticated economic analysis and techniques. And I think Doug was concerned about this as well. I agree that not only are courts and much less juries not prepared to fully understand all of this, But even the people testifying on the two sides, the economists themselves, that they often can reach different results using very sophisticated models, tweaking assumptions here and there, and coming up with opposing conclusions. Even the fan of economics and conservative thinker Robert Bork, it bears mentioning, was no fan of trying to use sophisticated economic techniques to try to calculate with any kind of precision or accuracy the competitive effects of mergers. He was a big fan of using presumptions when it came to mergers. Now, he would have challenged mergers that took 3 significant competitors down to 2, but permit maybe 4 to 3 mergers. And I'm pretty sure the current leadership of the agencies would draw the line somewhere else. But the difficulties in trying to use the most sophisticated economic techniques, it's not only that they're confusing, but it's that they can be very sensitive to different assumptions. They rely on imperfect data, and they have been shown on occasion to produce results that the real world, after the fact, failed to confirm. So despite the precision that appears there, they are imperfect. What I anticipate happening perhaps is that they will play some role, but as in the AT&T Time Warner case, as a most recent example, courts will be very interested in seeing how sensitive the results they come up with are to what might appear to be mild tweaks in the assumptions or in the level of the inputs that are going into the model. I mean, in that case, we had, Carl Shapiro and Dennis Carlton, 2 of the best economists one could hire. And Carlton purported to show that by changing some of the assumptions just a little bit that went into Carl Shapiro's model, the results could be reversed. And I think that was at least one reason why the court ruled in favor of the defendants. And I suspect that this kind of sensitivity analysis will be very important going forward. And where the results are very sensitive to such changes, then I think they will properly rely a great deal more on presumptions, as they should in such cases, and a great deal more on things like documentary evidence and that sort of thing.
Let me just, if I can, just say one smaller respect in which I might disagree a little bit with Ken and Bill.
Uh-oh, whenever Doug says that, I know I'm in trouble.
This time I mean it. I don't think, I think both of them were saying, I'm not sure if they meant to say this, but it sounded like they were saying, well, of course you have to start with market definition, because presumptions have to be based on some notion of who are the players in the market or who are the shares. I don't think it's desirable. I don't have a good alternative worked out fully in my mind, but I don't think it's desirable to say we always have to define a market. And what I have in mind are mergers in evolving industries, in complex industries, certainly the whole issue of nascent competition. Look at the Epic Apple case, when the parties propose their very precise markets, and the court said, "Oh, you can't come up with a third one that looks a little half-baked to me." That kind of dancing on the head of a pin about what are the boundaries of the market strikes me as often an unnecessary and sort of folly-laden inquiry. If we can look to other factors, Ken suggested one approach, which is 2 or 3 most significant competitors in the space, and not worry so much about defining shares and defining markets, but saying, look, these guys are different from the others, and so we have to worry about them. In some cases, I think that ought to be enough.
And surely there would be documents to help support who are the constraints and who are not. And again, I think that in many cases that ought to be enough.
And Doug, I don't think that Ken or I would disagree with you fundamentally. My view is that market definition is a easy and good starting point, but you should not treat the boundaries of the market as rigid, and should not put too much weight on that. my view is that rarely are the boundaries of a market black and white. There's usually a lot of gray. And so, one of the things that bothers me about the increasingly narrow market definitions that I think the two agencies have been relying on to win cases when they go to court is that they don't pay enough attention to growing competition from outside the traditional market boundaries. And I think one of the things that really influenced Judge Leon in the AT&T Time Warner merger case, which Ken mentioned, is that he saw in the parties' documents the growing competition they were feeling from digital competitors who were already beginning to take a larger and larger share of the market, which of course exploded when COVID hit us in early 2020. So you need to look at trends in the industry and in the marketplace. I won't use the term market and take into account growing competition from outside traditional market boundaries.
Agreed.
So one of the things that I think have caught a lot of people's attention was Assistant Attorney General Cantor talking about pursuing more merger challenges using the quote, tends to create a monopoly language in Section 7 of the Clayton Act. Ken, are there any indications of that in the RFI questions? And does that approach mean a return to the days of asking courts to arrest monopolies for so-called in their incipiency?
Yeah, well, let me try to be brief. I know we're starting to run out of time, but it's an important question. I do think that one of the tools that the agencies might want to use, and I think it is signaled somewhat by the fact that it came up indeed in the very first question in that long list of questions, had to do with the phrase "or tend to create a monopoly," that is part of the brief language in the Clayton Act. I think the focus has tended to be on substantially lessen competition, but I think there will be increasing interest in trying to use this "tend to create a monopoly" language to perhaps justify through legislative language challenges to mergers that may not seem to be very large and substantially lessening competition, but may be en route to doing so, perhaps as part of serial acquisitions that have been taking place in the market. And I think this would also have some implications for kind of rolling up perhaps too many of these nascent competitors or emerging technologies that could possibly lead to threats in the future.
Bill, Doug, any thoughts on that?
Well, I think you could look at that language and you could imagine that they're going to go back to bonds and brown shoe and say, well, yeah, sure, 5% is not a problem, but if everybody did it, soon we'd be down to only 20 competitors or whatever. I don't think that, I think there are probably some in the political appointees that might like to go to that world. I think they understand that in the absence of legislation, it can't get from here to there. So I would expect more sophisticated theories, maybe along the lines that Ken was talking about, where you look at a merger that's not harmful immediately, but you ask questions like, well, could it be harmful in the long run by making entry more difficult? Could it reduce the likelihood of innovation? What impact is it going to have in terms of the evolution and dynamics of the industry? I think they will be looking for stories like that they can then tie into the language of tend to or incipiency, which I think would be a legitimate way to use that language if the story holds, rather than simply saying, well, this is a small merger, but it's on, it's the first step in the journey of 1,000 miles. I don't think they're going to go in that direction.
Yeah, I'll try to be very brief because I think I agree basically with Doug and Ken, but I would have a slightly different twist on it. I can see using that language, tend to create a monopoly, when you're talking about a firm that already has I'll use the word dominant position in a market, a very large market share, in what could potentially be a growing market that's going to become more and more important, and asking is this acquisition, is the acquisition of a nascent competitor, quote unquote, going to entrench their already existing market power? Or is this a merger where the company that's seeking to acquire a nascent competitor, a new entrant or a potential new entrant, is doing so in order to actually increase competition in that market? You see that a lot in the pharmaceutical area, where a lot of the large branded pharmaceutical companies will acquire small nascent competitors who have promising therapeutics under development and going through the very lengthy FDA approval process, because they have the capability of bringing that product to market faster, more quickly than the nascent competitor does, and distributing it far more widely. That, in my view, is another one of these examples of a merger that's a mixture between a horizontal and vertical merger, where the vertical aspects of the merger may actually be highly pro-competitive.
So on the issue of mergers, on remedies, the request for information suggests an interest in adopting a formal process and deadlines for remedy proposals. What do you think would be the impact of such a process if that were to come out of the guidelines, Doug?
Well, I think you have to start with one thing, and maybe I'm being unfair, but if you look at what the FTC did over in the early months before Jonathan Cantor was confirmed, they took a lot of steps that have the effect, even if not the intent, of probably enabling probably deterring conduct, and in particular mergers, without subjecting the agencies to judicial review, so that it potentially enables them to achieve results they would like to achieve but can't achieve in the absence of legislation. And you look at the formal changes they made, prolonging merger investigations, eliminating early terminations, requiring pre-merger notification for more mergers, threatening heavy-handedly post-merger enforcement, investigating conduct broadly and with less oversight, repealing the guidelines, the vertical guidelines, requiring prior approval commitments and merger settlements, and investigating non-merger matters in the course of HSR investigations. So I think you have to be mindful that one of the possibilities is that they're seeking to deter. And here's what I have in mind. It's very possible that the procedures they're talking about will simply regularize and make more efficient the review process. And that would be a good thing. But it also is possible that the procedures will make it harder for the merging parties to salvage a deal, because there'll be procedural defaults and procedural constraints on their ability to do so. A deadline like buyer up front and so forth. So I suspect that the effect of this is largely going to be to make it harder to settle merger investigations if they promulgate rules. But hopefully it will have even a greater effect in simply making the whole process more efficient.
Yeah, if I could add to that, this looks like a solution in search of a problem. In my experience, merging parties want to get the merger review finished as quickly as possible. And if they think that remedies are necessary, they will propose those remedies to the agencies at the very outset, sometimes even before a second request is issued. Similarly, in the past, I think agencies have, because of the statutory clock they're under in HSR pre-merger reviews, will want to tell the parties that they think a remedy is necessary as soon as they are satisfied that one probably is, in order to expedite the process and allow everybody to get through it more quickly and reach a result that's good for the public generally. I really worry about trying to make the HSR pre-merger notification process any more cumbersome and regulatory than it already is. I've participated in too many parallel merger reviews going on at the Justice Department and at the Federal Communications Commission simultaneously, and knowing what having those kinds of regulatory procedural hurdles to jump through can really slow down the whole merger review process, and in some cases actually kill a merger. I really would hate to see us move in that direction.
Thank you, Bill. So since we are nearing the end of our time, I thought we'd go back to sort of the first question today, which was the purpose of the guidelines. Doug, do you expect that ultimately the guidelines, whether they're one document or two that come out of this process, do you think they're going to be constrained by the normative underpinnings of current merger jurisprudence, or are you likely to think they're going to take merger law off in a different direction?
Well, I think that's really the big question. I think it's clear that Chair Khan, Tim Wu in the White House, I don't know Jonathan Kenneth, so I can't speak to him. It's clear that the other two really aren't interested in an economically focused antitrust law that thinks of its purpose as preserving the competitive process as a means to promoting economic welfare. I think they really are concerned, motivated by other values, equality, fairness, and so on. And if they get new legislation that enables them to do so, I think they'll run with it. But if they don't get new legislation, while they'll argue that the statutes give them a lot of room to go in that direction, I would suspect that the guidelines they come up with, if they come up with guidelines, will be packaged in a way that will make it more likely that judges will accept and follow the lead. So they will adopt criteria that are not inconsistent with an economic focus, but try to move the bar a little bit and talk more about incipiency and some of the theories we talked about to get to a more aggressive antitrust enforcement without at least exclusively walking away from the economic focus of the interest.
So Bill, if the document as it comes out is more aspirational than reflective of current law, how do you think the courts would react to that compared to how the courts have viewed the guidelines in past years?
My view is that the courts generally move at a somewhat glacial pace when it comes to making fundamental changes in doctrine and in how the laws are interpreted. It took the Supreme Court nearly a century to overrule Dr. Miles, even though there had long been a consensus among probably both antitrust scholars, economic and legal, that a per se rule against resale price maintenance made no economic sense and was probably actually anti-competitive. When you think about the predatory pricing story, Filarita and Don Turner published their seminal article on predatory pricing in 1975, arguing that there should be an analytical framework with presumptions built in that prices that were above average variable cost were pro-competitive, not anti-competitive, not predatory. When did the Supreme Court finally adopt that test? 1992. By my count, that's some 17 years later. So anyway, I don't think changes in judicial doctrine take place instantaneously. It is true that there really was a very fundamental change from 1968 to 1979. But over that time, Richard Nixon and Gerald Ford appointed a majority of the justices of the Supreme Court due to retirements and deaths from the Warren Court. And at the time that change was taking place, there was an enormous change in the attitude toward regulation generally. It was a time when the inflation rate was, I think, 13%, and unemployment was 9%, headed up to 11%. So there was a lot of reason to be dissatisfied with the way the laws were being applied at that time, and a real recognition that their application needed to change. We may be in another pivotal moment like that now, another inflection point. Reading the popular press, you might think that there is, but I still don't think that we're going to see that kind of fundamental change that quickly in the courts.
I would just add one quick thing very briefly to that. One is, I think the makeup of the courts these days is probably not very receptive to such things, especially the Supreme Court. And number two, I think there might be some difference here between the FTC and the DOJ in that, near as I can tell and believe, the FTC is more willing to bring aggressive challenges, pushing the envelope, partly perhaps to demonstrate that when they lose in court, that the laws as they currently exist are insufficient to deal with the market power out there, and that would help support the push for stronger regulations.
So one of the reasons why the AAG Cantor wants to bring more cases and fight more cases sort of to an end and not accept a remedial approach is because he thinks there's not enough case law guidance out there for businesses when it comes to mergers. Is it fair to say that with the current makeup of the courts in mind, he may not be happy with what results that he gets in the end?
Well, I'm thinking that, near as I can tell of his background and his predilections, he might be marginally less likely to go that route than Lena Khan at the FTC. And I don't think he wants rulings that create bad precedents, whereas, again, I'm just speculating. I think Lena Khan and the FTC would be more willing to roll the dice, and if they win, great, and if they lose, it helps strengthen the push for strong legislation.
Also, to the extent that the commission brings administrative proceedings, judicial review is both deferred and narrowed. So they do have a little understandable reason to be less concerned about what the Article 3 judges are thinking than the others.
Well, that's true.
So how does this process go forward now, and how long do you think it's going to take them to get to an endpoint where they release the final document? I imagine Doug and Bill have thoughts on this.
I think they're going to feel under a lot of pressure to try to move this forward as quickly as possible. Comments are due on March 23rd, I think. They have to be looking at the electoral clock and the fact that there's an election this November. So I would think that there's a chance that they will try to get new guidelines out before the November election, or if not, very early in the new year before the new Congress takes its seats.
I'm right that the request for information is tendentious rather than curious. I imagine they're drafting the guidelines now.
Oh, I think they've already drafted the guidelines.
I was trying to be respectful.
I know you were, and I'm not.
So does that rapid of a process, you think, undermine their credibility in the courts?
I don't think so. I mean, and one thing about the courts that I think is worth mentioning is that I think that at the end of the day, even though they give some credence to what is in merger guidelines, I think the courts are far more persuaded by the logic of the arguments and the evidence that are presented to them, rather than saying, look at the guidelines, we win.
With that.
Gentlemen, thank you so much for joining us today, and thanks to everybody who took the time to watch this live. It's being recorded and will be available on our YouTube channel and on our homepage if anyone has an interest in watching it in full again, or if you came in late, or if you have a colleague that will benefit from it. I do hope that you share it with them. And again, gentlemen, hope you have a good rest of the month. Everybody take care.
Thank you very much.
Thank you very much, Glenn.